Afternoon if you're on the East Coast, or good morning if you're on the West Coast. My name is Judge Steve Leifman. I am the Associate Administrative Judge of the Miami-Dade County Court Criminal Division, and I chair the Florida Supreme Court's Task Force on Mental Health and Substance Abuse Issues in the court. I want to welcome all of you to this event. This is entitled Effective Responses to Defendants with Mental Illnesses. We're thrilled that all of you are here with us today. Joining me today is Dr. Fred Osher, who is the Director of Health Systems and Services Policy for the Council of State Governments Justice Center. The Justice Center is actually an organization that represents all three branches of government. They are a nonpartisan organization that uses data-driven information to develop policy recommendations, and they have been particularly involved with working on developing work to reduce the overrepresentation of people with serious mental illnesses in the criminal justice system. I also want to introduce Chris Seeley, who is the Program Director of School and Justice Initiatives at the American Psychiatric Association Foundation, and Dr. Allison Upton, who's also joining us today. She is a Senior Policy Analyst for the Council of State Governments, Council of State Government. I'm now going to turn it over to Chris to give us a little information about the American Psychiatric Association Foundation.
Thank you, Judge Leifman. The American Psychiatric Association Foundation is the charitable arm of the American Psychiatric Association. The APA Foundation is in the midst of celebrating its 25th year with a focus on creating a mentally healthy nation for all. At the APA Foundation, we know that 1 in 5 Americans experience mental illness in any given year. And so our programs not only support our APA members, but the general public to support the profession of psychiatry and to foster community awareness and engagement through our 15 programs, 25 awards, and 8 fellowships. Some of the program highlights include our Typical or Troubled program that aims to train educational staff in recognizing the early warning signs of mental health and helping them to refer students to appropriate resources. The Stepping Up initiative that works with county and state leaders to reduce the number of individuals with serious mental illness in our criminal justice system. Our Helping Hands grants that give medical students the opportunity to start or further community-based programs. And our work also extends into faith-based communities, veteran services, and in the workplace with our Center for Workplace Mental Health. I just want to take some time to thank our partners, Judge Steve Leifman, Dr. Fred Osher, Dr. Allison Upton, and everyone at the Council of State Governance for putting together this webinar. So thank you for those who are attending as well.
Judge Leifman, I'm not sure if you're on mute or not. If you
I'm sorry.
We're not able to. That's okay. So we can just start with slide.
Problem switching the screen. So
okay.
Just
we could start with slide 4 then.
Yes, we're on slide 4. If you go ahead and release, it's not letting me switch. So if someone would go ahead and switch to the next screen.
Go ahead. We did.
We're currently on slide 4.
Okay. I'm ready to go past that, which is just the overview and project. There we go. Could hit it one more time, please. Okay, the objectives today is to help judges learn more about the existing Judges and Psychiatrists Leadership Initiative resources, to hear about the Judges and Psychiatrists Leadership Initiative training available for judges in their jurisdictions, and to discuss strategies to become more involved in system-level work. We sort of look at this as our JPL Eye 2.0. We've done a lot of training over the last few years to help educate judges to understand how to recognize signs and symptoms in court, how to talk to people with serious mental illnesses, and work in their court system on how to deal with these issues. The objective of our program today is to also teach judges how to use resources, how to make better decisions, and how to work in the community to actually develop better systems of care. Next slide, please. All right. Prevalence of serious mental illness in the criminal justice system is really staggering. Each year we have about 2 million people with serious mental illnesses arrested. We have about 550,000 people with serious mental illnesses in jails and prisons today, and about 900,000 people with serious mental illnesses are on some kind of community control. You know, we all often see a lot of issues in the media, lots of headlines. You can see here from some of the smallest rural communities to some of the large urban communities, all of our media, a lot of attention is being given to this issue because, unfortunately, our criminal justice system has become the default for the mental health system in this country. We know that defendants with serious mental illnesses sometimes may be incoherent or present nonsensical responses to questions in court. They can be very disruptive. They can create time management issues for judges when we're dealing with our dockets. And there's a high recidivism rate, and they often are returning to court again and again and again. So the Judges Leadership, Psychiatric Leadership Initiative was really started several years ago when there was a recognition that, ironically, a lot of the reform in this field was coming through the judiciary. And we realized that judges wanted more information on dealing with the special needs of defendants with serious mental illnesses, that judges were looking for more information about available treatment options in their communities, and psychiatrists wanted to understand the legal requirements for their patients under court supervision, that just providing evaluations wasn't sufficient, that we really started to need to talk about how do we develop a better coalition between psychiatry and the judiciary to get better outcomes. And we know on a typical day our communities are looking towards leaders to address these very intolerable circumstances. So the mission of the JPL Eye is pretty clear. It aims to stimulate, support, and enhance efforts by judges and psychiatrists to improve judicial, community, and systematic responses to people with behavioral health needs who are involved in the criminal justice system. Our hope is to create a community of informed judges and psychiatrists, to increase the reach of trainings and develop educational resources that judges and psychiatrists can use to get better outcomes. And what we're finding is by doing that, by educating ourselves, that we are getting much better outcomes. And I think it's incumbent upon us, particularly as judges, to sort of use the same motto that doctors use, and that's do no harm. And while it's important and judges may want to get involved in doing things like mental health courts or diversion programs, if we're going to do it, we really need to understand these issues incredibly well, and we need to make sure that we're using evidence-based practices so we get the kind of outcomes that are desired, and we do more to help this population than to make the situation more difficult. I'm now going to show a short video that was produced by my local CBS 4 affiliate in Miami-Dade that does a fabulous job highlighting what the real horrors of this problem are when they're not treated appropriately. Thank you. It's a pretty sobering look at the state, not just our jail here in Miami-Dade County, but many jails around the United States. Sadly, the young man in the video passed away over the last year or two as a result of his injuries, and we believe his father passed away probably from a broken heart not too long ago. If you haven't had a chance to go visit your jail and see what's going on with the mental health population, it's something that you may want to consider doing. At this time, I'd like to introduce Dr. Fred Osher, who will now present an additional piece of the presentation. Dr. Osher, thank you.
Thank you, Judge Weissman, and thanks to the participants on the phone for taking time out of your busy schedules to join us on this important topic. At this point, I want to discuss why collaboration between judges and psychiatrists is essential. And while the video that we just saw was a poignant portrayal of what goes wrong, in order to get things right, it's not any one system's responsibility, but it is a multi-system response that's going to be required to address this overrepresentation. On this slide, you'll see that we have prevalence rates listed. On the left are those in general population, and we're talking about adults here. About 5% of our adult population will have a serious mental illness during the course of this year. In a study that colleagues and I conducted several years ago at 3 jails in New York and 2 in Maryland, looking at 20,000 consecutive bookings, we identified 17% of those booked as having a serious mental illness at that time. When you tease that apart, that represented 14.5% of the men booked into those jails, and a stunning 31% of women met criteria for a conservative diagnosis of serious mental illness. Of note is that of those individuals that come into jail with serious mental illness, almost 3/4 of both the men and the women have a co-occurring substance use disorder. And that's an important phenomenon. It may not be the reason why they are in jail, but it certainly complicates their efforts to get out of jail and to stabilize within the community, and needs to be accounted for in the programmatic designs that we recommend. The next slide is our effort to understand the factors that are responsible for this overrepresentation. Is it that people with mental illness are more violent? No, not necessarily, the research says, and that actually people with serious mental illness are more likely to be the victims of crime than the perpetrators of crime. But in order to have these high rates within our jail settings, they need to be arrested at disproportionately higher rates. And there's 2 factors that I'd highlight contributing to that. The first I've alluded to already, the co-occurring substance use disorders. So that if you have a serious mental illness, you're 3 times as likely as another person to have a co-occurring substance use disorder. And in our policies around drugs in this country, we've had a significant growth in our jail and prison population related to the war on drugs. And as a result, when you bring in individuals that are selling or trafficking or using illegal substances, you're bringing in differentially a larger number of individuals with serious mental illness. It is also the case that individuals with mental illness are overrepresented in homeless populations. Not having an adequate place to sleep makes you a very visible member of our community. This year, over 2 million individuals will not have an adequate shelter. About 750,000 people tonight will not have access to an adequate shelter. And that when you're on the street, you can become often the subject of law enforcement contact, resulting in arrest, oftentimes for misdemeanor offenses, but nonetheless brought into the jail setting. We then have to identify the fact that once in the jail setting, people with serious mental illness stay there longer. That's controlled for all demographics and charges. Judges are reluctant to release individuals out into the community, sometimes with stereotype and biases about their dangerousness. Sometimes there may be a bond that's set at $100 or more, and individuals with serious mental illness are significantly impoverished and may not be able to make bond. Their length of stay, both in pretrial and in sentence populations are as much as 2 times higher as the general population. And we know that very little amounts of time in jail can really mess up an individual's life. For that person with serious mental illness, it may disconnect them from their job so that they can't make their rent. It may disconnect them from their treatment team and providers and case managers. It may create a discontinuity in their medication. A lot of different factors that make jail a significant event and something that really needs to be reserved for those individuals that pose a risk to public safety. Third factor that I'd like to highlight is that there's limited access to health care in this country. We still have a large uninsured population. It's estimated that before the Affordable Care Act, that 9 out of 10 individuals in our jail settings were uninsured, and that it is the case that when you don't have access to health care and you have serious chronic conditions, you're likely to have more disabilities as a result of that. It is also the case that when you get to a facility, a community center in many of our communities, that sometimes you don't see the evidence-based practices. You're not a recipient of the science that shows with good care, good outcomes are possible. I'll highlight that in the arena of co-occurring disorders. I mentioned already that 3/4 of adults with serious mental illness have a co-occurring substance use disorder. The evidence-based practice of choice for that co-occurring condition is integrated care, treating both the substance use disorder and the non-addictive mental illness as primary and requiring immediate attention. Unfortunately, there is insufficient integrated care available in our communities, and many of our community behavioral health practices still have a separation between our addiction providers and our mental health providers, and that gap needs to be filled if we're going to honor the evidence-based practice associated with good outcomes. It is also the case, as Judge Leifman alluded to earlier, that once you go out into our communities, you may not be connected to care in a meaningful way, and you're a part of this revolving door population. In and out and in and out they go. And that individuals with serious mental illness are significantly more likely to return. In a study conducted by Jennifer Skeen and colleagues of 3,000 probationers, individuals with serious mental illness compared to those without were arrested at about the same rate in community, but the individuals with serious mental illness had significantly higher rates of technical violations, violating the conditions of their release, oftentimes difficult to adhere to, with meetings to show up for, treatment to attend to, medications to take, fines to pay, and technical violations are oftentimes part of the overrepresentation of people with mental illness in the criminal justice system. And then I think it's important to recognize that people with mental illness get arrested for many of the same reasons that individuals without mental illness do. The next slide represents a study that was conducted in Minnesota, in which 400 consecutive admissions to the Minneapolis jail that were identified as having schizophrenia were interviewed and asked, what is it that got you in trouble? How did you end up getting arrested? And somewhat counterintuitively in this cohort, which has been repeated in other studies, that a very small minority in this study, about 7.5%, acknowledged that their mental illness was directly responsible for arrest. That circumstance would be an individual with schizophrenia, having auditory hallucinations, not taking medication, voices tell them to hit that person, they hit that person, and now they're arrested, directly related to their mental illness. It turned out that another about 10% indirectly related, have schizophrenia, not able to work, really in need of food, shoplifted, now I'm picked up, I'm in jail. But for over 3/4 of these individuals, they're in jail, at least in this study, for reasons other than their mental illness. And it turns out that those reasons are very similar to individuals without mental illness. In the next slide, you'll see that in a study of 3,000 probationers, those with mental illness had more of the risk factors associated with rearrest and violation of conditions of release than those individuals without. And so I'd like to spend just a little time in our webinar today with Risk, Need, and Responsivity 101. So on the next slide, I want to define for us criminogenic risk, and it's a term that is common in sociology and criminology circles, a little less commonly used within behavioral health circles, but criminogenic risk does not refer to crime type or whether that individual is likely to appear in court or not, or if they're dangerous, or relates to their sentence or disposition or custody or security level. Those are all important factors. But when I use the term criminogenic risk, I'm referring to how likely is that individual to commit a crime or violate the conditions of their supervision. And on the next slide, you'll see that this is a phenomena that is measurable, and that there are two main dimensions that our instruments look at in deciding what risk band any individual may fall in. There are static factors, and those are criminal justice history, number of arrests, number of convictions, type of offenses. Those are the static factors. Nothing you can really do to change those, okay? Men more risky than women, young people more risky than older people. Next slide, please. But importantly, the second set of conditions that are measured in establishing risk are what we call dynamic factors. And they're called dynamic in that they are changeable, and that's really an important construct in that there are things one can do to mitigate the likely of these central 8 risk factors to have an impact on that individual's community tenure. So that these are called the central 8. They emerge from the literature as 8 factors that explain oftentimes why people get in trouble, and oftentimes that applies to individuals with serious mental illness. I had already mentioned to you high rates of co-occurring disorders, and substance use, substance-related abuse-related behavior drives a lot of crime and arrest in our country. So too for people with serious mental illness. The next of these sets of factors are history of antisocial behavior, antisocial personality pattern, antisocial cognition, antisocial associates. These are all issues that in earlier days we would, in our diagnostic schema as behavioral health providers, we would relegate these features to what was known as Axis 2, where we put personality disorders. And antisocial personality disorder was among that categorization. And that we were taught years and years ago that there was very little you could do about Axis 2 disorders because they were egosyntonic. That is, they didn't bother the individual as much as the folks around them. It turns out that we were dead wrong, and that it really is possible to influence the way people think and feel with these disorders. And as a result of that, there are some opportunities for us to discuss about what interventions might make a difference for individuals with serious mental illness. The next slide then takes the understanding about these risk factors and puts it into a paradigm that's driving a lot of correctional practice and policy at this point in time. And it is the risk, need, responsivity model. And that in this model, what we're talking about is that we can measure risk, as I just defined, the static and dynamic dimensions, sort people out into risk bands from low, moderate to high. And the risk principle suggests that if we are going to have an impact on public safety, then we want to make sure we focus our intensive resources on that group of individuals that are higher risk for coming back into jail. And that for those lower risk individuals, not that they don't need important support for their behavioral disorders, but we may not want to apply as intensive a supervision model for them. So that these lower risk individuals aren't likely to create new victims in the community. They really ought to be moved out quickly and access treatment, but not necessarily followed so closely by supervision that they will automatically violate the conditions of their release. The risk principle says in this era of scarce resources, if you want to improve public safety in our communities, make sure you focus on high-risk cases. The need principle in R&R relates to the fact that the factors that get individuals in trouble can be assessed, and if you're an individual with those criminogenic risk factors, abusing substances, hanging with the wrong people, underemployed or unemployed, that we really want to focus our treatment interventions on those risk factors to get pro-social friends, to decrease and stop the use of substances that alter the way you think and feel and behave, that we can then, help with supported employment programs, get people, even with very serious mental illnesses, to work and on the job and becoming tax-paying citizens. The needs principle says the more of those needs that are identified and are the target of your interventions, the less likely that individual is to return to jail or prison. And lastly in R&R is responsivity. And by that, we're talking about an awareness that people learn in different ways, take information in different ways, and we want to accommodate our interventions to the cultural differences that are there. And one of the responsivity factors to incorporate is mental illness. You didn't see mental illness in the list of top explanatory factors for jail. That's because it's an associated factor. It's a responsivity factor. It impacts a variety of dimensions, and that treatment for mental illness is absolutely necessary for those that are identified as having disorders, but it isn't necessarily sufficient to keep that individual out of justice settings. We want to bring in our current understanding of risk and needs to design treatment and supervision strategies that address and mitigate those circumstances that bring people back to jail. The next slide is a national effort that I just want to highlight at this juncture that many of you have heard of. It's the Stepping Up Initiative. It's a joint venture in partnership with American Psychiatric Association Foundation, the National Association of Counties, and the American Psychiatric Association Foundation, in which 2 years ago there was a call to action and a challenge. Can counties, 3,069 of them in this country, step up to, in a systematic way, look at the factors that we've been discussing today and design strategies that will make the prevalence of serious mental illness go down in our jail settings? And to date, we have over 400 counties representing almost half the adult population in this country that have stepped up, that county council men and women have passed resolutions that say the status quo is not tolerable and that we as a community are going to come together and ensure that individuals that don't pose a public safety risk are returned to our communities and supported in a way that allow them to both desist from crime and move forward with their own recoveries. On the next slide is a map of the existing counties that have passed resolutions at this point in time, and that our hope is that if your county doesn't appear blue on that map, that perhaps a discussion with county council would be appropriate, and that we would direct you to our website, which is www.stepuptogether.org, to get more information about that initiative. All of these factors, as I've described, are challenges to address, and challenges for the judges who are the target audience for our new educational material. That there is, for a judge, a need to understand what treatment's needed and what the risk is for individuals that are coming before the bench, so the supervision can be designed appropriately. We are also aware that sometimes treatment referral from the bench doesn't always match the clinical need of that individual, and that creates a challenge for both the community providers and judicial expectations. Treatment may not be available for the defendant in the community, and that needs to be understood. What treatments aren't at the level, capacity levels that we anticipate, and how do we then fill those gaps? And that it is really critical that collaborative mechanisms between the court and community providers get established so information can flow protecting individuals' protected health information, but at the same time exchanging essential information to support that individual in their recovery going forward. So at this point, I'd like to turn it over to Dr. Upton to talk about how the Judges Psychiatric and Psychiatrist Leadership Initiative has sought to create products that will address some of the factors that we've outlined in our problem statement. And so I give you Dr. Upton. Allison.
Thank you so much, Dr. Osher. Appreciate it. And thank you to the panelists, and also so glad to have all of the participants on the line. Thank you for sharing time out of your busy schedules on the webinar today. And did just want to quickly, before I move on with my content, let the participants know that if you have any questions, we will have a question and answer portion at the end of the presentation today. But you can also feel free to type in any questions you have in the Q&A chat box in the WebEx platform. It should be, I believe, in the bottom right-hand corner of your screen. Feel free, if your questions come up, to chat them into us, and we will pose them as we can during the question and answer portion. Okay, so I'd like to spend some time now during this section of the presentation discussing a variety of resources that we have, some existing resources through the Judges and Psychiatrists Leadership Initiative, or JPL Eye for short, and also then to tell you a bit about the newest resources that we've developed that Dr. Osher mentioned that we're very excited about. But let's first start with some of the existing resources that judges and other court personnel we hope you will access. So as your slide shows right now, we have currently available already 3 judicial guides that are available at a very low, very nominal cost, very easy to order. And if people are interested in ordering these materials, please feel free to, again, type in your email address directly, or you can also contact us after the presentation. We'll be putting our contact information up on the last slide of the presentation, and you can certainly contact us, and we can let you know how these resources can be ordered. But so we have already, JPL Eye has produced some very useful judicial guides. As you can see, we have the Guide to Mental Health Jargon, the Guide to Mental Health Diversion, and the Juvenile Mental Health Jargon Guide. And so to start with, the Mental Health Jargon Guide is really a very handy and quick reference for judges to use. Typically, judges may be receiving, medical records pertaining to a particular case that they have on their docket. They may get evaluation or assessment results. They may be getting, say, treatment updates from providers or status reports. And like with any discipline, I think clinicians often have their own terms, sort of their own lingo that they use between themselves related to maybe medication types, treatment types, diagnoses. But to others, it's hard to necessarily sort out all of this jargon. And so this is actually a very helpful, quick reference guide that explains a lot of the common terms that are used by behavioral health providers in the community in terms of their work with adults. And so, what you can't tell from this photo is actually that these guides are handy and portable. They're very practical for judges to use. They can probably fit in the palm of your hand. That's about the size they are, and so they're easy for judges to take with them as they move from courtroom to courtroom or location to location. And this is just one really quick way that they can look up particular behavioral health information and acronyms and terms that to get a quick description of what providers might be speaking about. And then you have the comparable judicial guide for juvenile mental health jargon in terms of referring to work with youth who have justice system involvement. And also very helpful is the judicial guide around mental health diversion. And this is actually a very interesting and helpful resource for judges or for others really in any jurisdiction who are interested in developing and enhancing the court and diversion programs in their area. Again, the guide is a quick reference, but it also contains links to a lot of other sources of information. If you're interested in one particular area contained in the guide, then you can link and read more about any particular topic if you're interested. And so it contains subjects like defining diversion. What exactly is diversion? What are the different types of diversion that are common that we see around the country? This particular guide reviews the concept of the sequential intercept model, which is a mapping exercise that can be used in your jurisdiction to look at the diversion activities that are already in existence, what is working well, where there may be gaps that you want to try to enhance, for example. And even in your jurisdiction, if you have not done any diversion so far, it's still a great place to start. It's a great resource for judges and other court personnel because it reviews topics such as how to even get started in your jurisdiction, who to bring to the table to start discussing diversion and what the options are. So we really hope that you all, that the judges that are in attendance today and the other court personnel, anyone that's interested will consider ordering these guides for your jurisdiction. Again, they're very modest prices and really very helpful resources to you all. So these guides are in existence. And then what I'd like to tell you about is some of the work that we've done over the past year actually to create our newest judicial resources. We created a longer judicial guide that's about 15 pages long and also a portable bench card. And really in our work with grantees and in the JPL Eye work around the country, we're constantly hearing feedback from judges, from court communities. And we really hope we have a lot of ideas for future product development, and we really tried to narrow down in this project work over the past year our focus around working with defendants with behavioral health needs and helping to develop some resources for judges in terms of information that could help guide their decision-making process around setting conditions of release and sentencing with this target population. So in this newest project, we really tried to create practical tools for judges that would help judges recognize when actually defendants have behavioral health needs. This is actually just a process where judges can actually be very active in terms of some early observation, and I'll speak about that a little bit more as I go through some of the slides, but where judges can be very active in terms of observation to try to identify the possibility that a defendant might have a behavioral health need. We wanted to, through these new educational materials, we wanted to help judges understand the processes of screening and assessing people for behavioral health needs, understand these processes better. These processes happen pretty routinely in terms of by behavioral health treatment providers, but not necessarily so common in courts. And so we wanted judges to have a better sense of what those processes are like, and actually when is the optimal time to refer to behavioral health clinicians, to use clinicians as a resource for the court to help support decision-making processes for cases. We also wanted to cover and provide information around a lot of strategies for collaboration with community providers. The Judges and Psychiatrists Leadership Initiative, one of its main efforts is to create these two great professions, judges and psychiatrists, who have a lot of overlap in terms of working with this group of individuals with behavioral health needs, with mental illness and with substance use disorders. And so there's a lot of overlap there. And so JPL Eye aims to really provide training and resources and also to help enhance the collaboration between these two disciplines to the effect of hopefully having good outcomes for the target population. So we wanted to get into more depth to provide judges with information about how they can identify treatment providers in their jurisdiction. Treatment providers change from jurisdiction to jurisdiction. Sadly, it's not a simple formula all across the country. There are a lot of regional differences, et cetera. And so we wanted to give information to judges about how they can identify treatment providers, how they can contact those treatment providers in their community, use them as a resource for the court, and really to turn these contacts into a meaningful collaboration that's going to be helpful to judges. There's also, with this particular target population of defendants, very often there's a very complex list and lengthy list of needs that they may have. They may have needs around their mental illness, around substance use, certainly around recidivism risk, criminogenic risk, needs around housing and medical needs and family and children, et cetera. And so, when you do start to gather information about this population, sometimes you can get quite a lot of information, and then the judge really is tasked with sort of integrating all of this information into their decision-making processes. So we wanted to try to hopefully provide judges with some tips, some considerations for this decision-making process. And so really, as we develop these new resources for judges, we also just want to point out that we kept several outcomes in mind. We certainly wanted to keep public safety at the very highest priority. We also, wanted to make the point that if judges at the courts are giving defendants the opportunity to get connected to treatment resources in the community, then obviously we are ideally hoping that people are complying with that opportunity to get connected to treatment. And so we really wanted to try to provide strategies to judges that might help enhance compliance in terms of working with this target group of defendants. And naturally, we also hope for good behavioral health outcomes for the individuals in question, for the particular defendants. We hope that they can move forward in the recovery process. And really, as a whole, I think that, again, in the ideal, if there is earlier identification of behavioral health need, if there is ideally more efficient and more effective collaboration with treatment providers and connection to treatment, then ideally some of the disturbances that can happen in courtrooms that Judge Leifman alluded to earlier, where people with behavioral health needs can perhaps be disruptive to court functioning, create delays, particularly when they are destabilized or disconnected from their typical treatment. We would hope that with all of these strategies and resources in place that there would be minimal delays in terms of case processing in the courts. And so we set about for the past year, one of the main projects that we worked on in JPL Eye was to create these new resources. And so, wanted to tell you all a little bit about the process for the development of these resources. Not only, of course, did we rely on the expert judges and psychiatrists that make up the JPL Eye leadership team, excuse me, but we also, of course, looking at the best practices and the research in the field, but we also had the really unique and interesting and fruitful opportunity to hold a day-long convening meeting in our headquarters are the Justice Center's offices in New York City, and we invited several groups of people from around the country, trying to represent both urban and rural jurisdictions in all areas of the country. And it was a really unique opportunity because we really tried to invite 4 different groups of individuals or experts to the table to participate in these discussions that we knew would be heavily informing the development of these resources. So we invited judges and psychiatrists, and we invited people with their own lived experience of being involved in the criminal justice system, of having a mental illness, and also sometimes having a co-occurring substance use disorder. And we also invited people who were family members of folks who had been involved in the justice system and had these behavioral health issues as well. So it was a really unique opportunity to get these 4 groups of individuals to the table and to really hear the different perspectives and of all the group's experiences. And so we had a variety of discussions throughout the day. We discussed hearing, again, from all the different groups represented, some of the strategies that had worked in courtrooms in terms of working with people with behavioral health needs. What had worked well, what had helped things go smoothly in the courtroom. We heard about that from judges' perspectives, also from people with their own lived experience. We heard it from their perspective as well. We heard about some of the challenges that realistically were faced in the courtroom, again, from all different perspectives. And then also we spent a lot of time discussing sort of strategies for overcoming these challenges and how maybe some tips and considerations that would help inform judges what tips to consider in terms of their interaction with defendants with behavioral health needs, what could hopefully make things go smoothly, increase compliance with court requirements. We also spoke a lot about collaboration with behavioral health treatment providers. Again, there's a lot of information that is out there about the types of care that are available, sort of the systems of care, the types of treatment available, the types of diagnoses that people have. There's a lot of behavioral health information out there. And so we spent time sort of culling down what types of information, what content and what amount of information is useful to present in these resources to judges. What are they really going to use on a day-to-day basis? We really wanted to make something that is going to be practical for judges to use. So we spoke a lot about that. And we also asked all of the attendees to the convening to really give their feedback around tips, around ideas and strategies to help inform judges when they are making these complex decisions around sentencing and setting conditions of release, and what tips and strategies might be helpful for judges to hear. And so I just want to share a little bit with you, I think, some really meaningful feedback, some of them, of a lot of the meaningful, just a snapshot of some of the meaningful feedback that we had from the convening. And so this first slide has a picture actually of Judge Leifman and Dr. Osher presenting today, who are members of JPL Eye, and so of course participated very actively at the May 1st convening that we had. And so, you know, I think this quote from Judge Leifman really just poignantly captures you know, the state of the state, if you will, and why we developed these resources, why we have the JPL Eye, right? So Judge Leifman said, I see more people with mental illnesses in my courtroom in a day than a doctor might see in a month. That's a sad commentary on the system. Hopefully one day the criminal justice system will be the last resort for people with serious mental illness, not the front door, right? And another quote that we really wanted to share with you today is a quote from a woman named Jayette Lansbury, who is the Criminal Justice Chair of an organization you may have heard of called NAMI, the National Alliance of Mental Illness. She's very active in New York State and actually nationally. And Ms. Lansbury is a very active advocate, and she is also a family member of someone who has had extensive involvement in the criminal justice system, who also has a very serious mental illness. And so she really, you know, brought a very important piece of the family member perspective to the table in terms of the feedback that we receive. And so Jayette, you know, shared that families are often the first responders, and when one person is arrested, in a way the whole family is arrested. And so I think that, you know, this is a really important point, that when there's one person that has behavioral health needs that is arrested, of course there is a ripple effect on the family members, on the support system, however that's defined for that individual. But there's another way also to look at this, which I think is interesting in terms of a judge's perspective, because judges may not always take this approach with other types of defendants. But with defendants with behavioral health needs, the family members or the support system may actually be a resource to the court, potentially. So the family members have a lot of information about their family member that was arrested. And they may have information about what works well in terms of helping that person in treatment, what works well in helping them avoid arrest, what is problematic in their case. And so it might feel like a little bit of an unusual strategy, but this is one strategy that is discussed in the guide, and actually Judge Leifman will speak about a little bit more later in the presentation. But this idea of collaboration with the family member is an interesting one as well that came out of this convening that we had. And just, you know, one other quote to share with you from the convening from an individual named Peyton Blau, who has his own lived experience having a mental illness, a serious mental illness that did impact his involvement in the justice system. He was arrested several times when he was a bit destabilized. And so he has actually, you know, in the recovery process, he has become actually a very well-known and actually national advocate, spends a lot of time speaking around the country about his experience. He's active in legislative efforts in his state, and he also really spends a lot of time working with police departments around the country, actually sort of teaching strategies for responding to people with mental illness, particularly de-escalation techniques and strategies that police can use that will help them work more effectively with people with serious mental illness. And so, Peyton, it was just a pleasure to have him at the convening as well, and he really made the point that something as simple as the language a judge uses when speaking about mental illness can make a huge difference in the courtroom. And this is a really important point, because sometimes we can't do certain strategies because of a lack of resources, but language doesn't cost anything, right? So judges can think about the language that they're using from the bench and how in particular it might have an impact on this particular group of defendants with behavioral health issues. And so this is just a really important point that we wanted to highlight as part of the convening. Okay. And so we gathered all of this information from the convening and from all our other resources to develop the these newest judicial resources, the first of which is this Judicial Guide, which I mentioned is about 15 pages long. And so here's a snapshot of the cover for you to see. It's called Practical Considerations Related to Release and Sentencing for Defendants Who Have Behavioral Health Needs, a Judicial Guide. And so we would be more than happy to provide you the link to access this. It is in the public domain. It's on our website. And so we really hope you will take the time to look at it at your convenience. And so I can tell you a little bit about some of the topics that are covered in the guide. We have included an overview of the risk need responsivity model that Dr. Osher covered with you during his presentation today. We cover an overview of the treatment referral process, which I'll talk about a little bit more during my time today. And we also cover in this guide some information for judges around resources to help recognize indications of a behavioral health need in the courtroom. So I'm going to speak about that as well in a little more detail. In the guide, we also provide a lot of strategies for identifying behavioral health resources in any particular jurisdiction. Again, as I mentioned, the resources of treatment and other services differ jurisdiction by jurisdiction, so there are some strategies that we are suggesting that judges can take to try to identify providers that they might be able to collaborate with, and how to find them, how to find qualified providers in the community, and also when to refer defendants for further evaluation, and when to sort of start the process in terms of working together with providers. When is it most useful for the court as a resource? And we also provide some guidance to judges as well on how to enhance collaboration. So you can contact providers, but how do you build that initial contact into a collaboration that's going to serve both the court and the provider well? And so just a little bit more today before I pass over to Judge Leifman shortly, but we wanted to just sort of cover in a little more detail some of the topics that are contained within the guide, sort of to whet your appetite for more reading in the guide. But so we really have in the guide tried to look at this process of determining behavioral health treatment needs. So this is not something that we do by instinct. There are processes that we can go through. Judges can do some parts of the process. Other court providers, court personnel can do some parts of the process. Other times it's better for trained personnel or clinicians even to do certain parts of the process. But we've divided this process into sort of 4 stages for learning purposes. So it starts with observation, and then the next stage is screening and assessment. Both of these processes, screening and assessment, are described in more detail in the guide. And then ultimately this process, if there is a behavioral health treatment need, would lead to treatment recommendation and referral information that can be used by a judge to help inform their decision-making processes on any given case. And so I'm going to focus a little bit more on the first stage of this process called observation, because this is actually where a judge can be quite active in terms of what they can do from the bench. And so we actually have an existing resource that was produced through JPL Eye, pardon me, that I'd really like to highlight today, because I think it actually can be an excellent, excellent resource to judges out there. And in fact, correct me if I'm wrong, Dr. Osher and Judge Leichman, but I believe to date this is actually the most requested resource that has been produced by JPL Eye. And again, it's available at a very nominal cost. The PDF is available in the public domain, and we have laminated versions of this, bench card, but they're available at a very nominal cost if people are interested. And so this resource I'd like to highlight for you is called the Judge's Guide to Mental Illness in the Courtroom. And the next slide you'll see before we move on. But Keisha, maybe you can just flip so they can see. Yes, you can see what it looks like. We have a snapshot of it. It's a two-page, sort of a standard paper size bench card. So again, it's very practical, very portable. Judges can carry it with them to different locations. And this resource, this guide, is very helpful because it details various categories of observation that judges can make, even when they're on the bench, even in just a few minutes. Judges can actually observe quite a lot about defendants, even in a short amount of time. And so the card details several categories of observation about a defendant, including the defendant's appearance, their affect, their expression on their face, their mood, excuse me, their speech, their thought patterns, and their logic. And so if judges can take the opportunity to, when they are seeing defendants, to observe these different categories of observation, they may see certain red flags, certain indications that something is maybe different about a particular defendant. Now, these observations, of course, don't necessarily mean they're not definitive signs of a mental illness, but they are sort of red flags, if you will, that might, that might lead a judge to think, pause and think, I wonder if this defendant has a behavioral health need. Let's take some action to try to figure that out. And you can move to the next stages of the process, calling in some trained personnel, whether that's other trained personnel or a clinician themselves, to conduct screening and assessment processes to actually see if a behavioral health need does exist. So it's a very useful way, a tool and resource that judges can use to try to very early on in the process observe some red flags, some indications that there might be a behavioral health need going on with a particular defendant in their courtroom. And so now what I'd like to do is to turn the presentation back to Judge Leichman, who will talk a little bit more about our newest judicial bench card. Judge Leichman?
Thank you very much, and again, thank you to all the presenters. So the newest piece that we've put out for judges and psychiatrists is really some of the practical considerations. How do you determine if there's a behavioral health need, and some of the do's and don'ts that we want judges to do if they make an identification. And so on the next slide, you'll see that it kind of gives an overview of the treatment recommendations and the referral process. It talks about practical considerations for judicial decisions, making related conditions of release and sentencing for defendants with behavioral health. And so, what happens is we're starting to do a much better job of collecting the right kind of data and information on individuals that are coming through our system that may have serious mental illnesses. But the challenge is then, how do you use that information to get the better outcome? And so this bench card lists some do's and don'ts that I'll go over with you in a moment, and it gives tips for judicial points of contact when someone comes in first appearance or the arraignment or the bail setting, as well as when they come in for sentencing or an update or a hearing appearance, how we may want to respond once we've identified that there may be a mental health disorder. So some of the do's that we strongly recommend that judges use is that we want defendants to have a voice in their treatment decisions when possible. You know, a lot of times, you know, just because someone is ill doesn't mean that they don't understand what is going on or what's worked with them for them before. A lot of times you can ask defendants, you know, what medications have worked for you in the past? What do you prefer? And what we find is that when you make the defendants part of their treatment plan, A, they feel respected, they feel part of the process, and they're much more likely to comply, which is what we want to do. We always want to have a calm and consistent tone, even if they're being disruptive. What you need to understand is the vast majority of defendants have very serious trauma histories, and when they're in court, they're anxious, they're nervous, it may be exacerbating their illness or re-traumatizing them, and you don't want to say anything or do anything that's going to make that situation worse. In fact, one of the things that I do that I find very helpful is when I do identify someone that has a serious mental illness, if it's not the mental health docket per se, but we're in a courtroom full of people without mental illnesses, I ask the person if they're comfortable talking to me on the record about their issue. If they're not comfortable, I often invite them up to the bench with the lawyers so that we can have a more intimate conversation and, again, make them feel more comfortable. I mean, could you imagine, you know, being in court and start asking someone about their heart disease or their cancer? You would never do that, and we shouldn't treat people with these illnesses any different. We want to rely on qualified clinicians and doctors to conduct screening and needs assessment so that, you know, we have good information that we can rely on. We want to incorporate the results of our assessment, and a classic example would be if you do a risk and responsivity assessment and you find that the person is a low-need, low-risk individual, there's no reason to hold on to that case for a long time. In fact, if it's a low-level misdemeanor in Miami-Dade, chances are we're just going to dismiss the case in that situation and send the person back to their provider because we know statistically that they're not going to come back. However, if they're a higher, moderate to higher need, higher risk individual, then we're going to want to make sure that we have them come more often, that we make sure they're getting hooked up with both the right kinds of treatment and, if necessary, cognitive behavioral therapies that will help address some of the issues Dr. Osher referred to earlier. We want to make sure that we set our conditions so they're appropriate and achievable. I mean, sometimes probation conditions can be quite onerous. Most of this population doesn't have transportation. Most probation officers usually are not located in the areas that most of these individuals live, and we often set these individuals up for failure. And so we want to make sure we set conditions that account for that. You want to consider calling complicated or time-consuming cases for people with serious mental illnesses at the end of the docket. And as we often say, better to spend a few more minutes up front than have to spend a lot more time later because the person isn't getting what they need. Also, one of the things that we do in our courtrooms is we also train the rest of the personnel, the corrections officers and the lawyers and the clerks, so that they don't do anything or respond in a way that may make the situation more difficult. Now, some of the don'ts that are on the new judicial bench card is that we shouldn't use our gut. There's all kinds of studies that show just using instincts or gut to make a decision is horrible, and you get really bad outcomes, even though you may be 100% sure inside. But the reality is, use the data that you have. It'll help you make a better decision, both for whatever conditions and sentencing you're going to use, and you'll get better outcomes. Make sure that you use language on the bench or don't use language on the bench that could be perceived as threatening, confrontational, or disrespectful. Again, as I mentioned, a lot of these individuals have serious trauma histories, don't want to re-traumatize and make things worse. Don't use legal jargon that may not be understood by defendants. I know that we all have a tendency, because we do this so quickly and so often, to use phrases that people may not understand. Remember, these are mental illnesses. It's not a mental illness. And one size does not fit all, and so we don't want to use an approach that you think will work for everyone, because it will not. Not only are these different illnesses, but there's different levels of acuity of these illnesses, and so we want to make sure that we fashion a sentence or an outcome that works for this population by actually figuring out what they need and making sure they have access to that. Try not to impose fines and fees that are going to be unaffordable for this population. Because if you do that, it's going to have a dire effect on them. They don't have the financial resources. It could affect their employment opportunities. And sometimes, you know, by trying to do the right thing, we may be actually digging a hole for these individuals that they never can get out. Don't overcomplicate when setting conditions. Try not to do too many appointments. Try not to be overwhelming. Try to work with the individual to see what's going to work. And those are a list of the don'ts that we strongly recommend you adhere to. Some of the strategies, we want to cultivate relationships with the existing experts in the behavioral health field. You know, I've been very proud of the relationships that we've been able to develop here in Miami. It has really given us some tremendous information. And we want to consult with a court resource coordinator or a specialty court personnel to help us get this information so that we can make these better decisions. If you're in a community, you may want to speak to in your community where you're not sure where to find information on who the provider might be. Your local Department of Children and Families or Health and Human Resource offices often may be able to help direct you to the local providers in the community, or you can even reach out to the local NAMI and folks who may have information for that as well. It helps to seek out the local psychiatrist, the community behavioral health provider, or a provider that may be affiliated with the local hospital. And one of the greatest things I think about being a judge is that we have this wonderful moral authority and that we can convene meetings in our communities to help solve these problems. We all know that when we invite people to a meeting, they generally come even if they don't want to be there. So I would strongly suggest you utilize that wonderful authority to help fix this problem. Because it's really not just about developing a mental health court. It's about helping develop a systematic change so that less people come into our system, and when they do come into our system, we have a system in place to help divert them into appropriate treatment. Questions that you may want to consider when you want to talk to the behavioral health experts. You know, what types of outpatient mental health or substance use disorder treatment can you provide? What are the eligibility criteria for these programs? And sometimes these eligibility criteria may not even exist, and you might be able to sit down with the mental health providers to help develop it. Do you have experience working with people in the justice system? And are you interested in gaining this experience? Remember, about 40% of people with serious mental illnesses in the United States at some point are going to come into contact with the criminal justice system. A lot of times the doctors may not even know they've had contact with the criminal justice system. So it's the kind of dialogue and conversation that is really healthy to start. And with proper consent, you want to ask them, do you have capacity to provide consistent, accurate reporting to the court about participant attendance, engagement, and other details for court-ordered treatment? We, in all of our programs, require all the providers that we work with for every court hearing to give us usually maybe a paragraph or two written on how the individual is doing, if they're attending, if they're programs, if they're participating, what kind of participation, have they been drug tested? If so, what kind of results are you getting? So that we have the kind of information we really need to make these informed decisions. So remember, we're trying to collaborate between the court, the behavioral health providers, the defendant, and their family members when appropriate. We want to engage. We want to maximize trust and engagement with defendants and support systems in both the court and treatment processes. We want to make sure that we use reliable information. We want to base our decisions on information from tested tools, from qualified professionals, and knowledgeable people with the defendant's family or a larger support system. We want to do individual decision-making. We want to be relevant to the defendant's unique needs and be mindful of the resources that are available to access the jurisdiction where they're living. And we want to be adaptive. We want to be aware of the treatment conditions may need to be adapted over time in response to dynamic legal and clinical recommendations. Now, I also understand that sometimes you may do these wonderful assessments and the kinds of treatment and programs that you need just aren't available yet in the community. But I'm a firm believer that once you start to identify what needs are missing, that it's a lot easier to start to work with your local government or local state authorities to be able to get those resources later. I want to give you an update on the Forgotten Floor. We showed you the original Forgotten Floor from 2006, and this is where things are today, because as we realize that things do change, and by having the courts become more involved, it's remarkable the kind of changes we're able to get. Please show the video. the new facility that we have in this video, it's not about building a new jail for people with mental illnesses. It's about making systematic changes in the community so that we can spend our resources more appropriate and help access to treatment for individuals with serious mental illnesses. In fact, the reason we were able to do this is that we now have the largest trained squad of CIT officers in the United States down in Miami. We have over 5,600 officers trained. The number of arrests in Dade County went from 117,000 a year to 56,000 a year, primarily to the pre-arrest CIT program. We have 3 post-arrest diversion programs, and all of this has contributed to a significant reduction in both arrest and the number of people with mental illnesses in our jail. In fact, our jail audit has almost been halved as well, giving us more space and allowing us to close the local jail. At this time, I'd like to open up the discussion for any questions. If you do, please go to the question and answer box, send the question in. They will be routed to us immediately, and we'll be happy to answer whatever questions you have. Again, I want to thank all of you so much for your willingness to participate today. I want to wish you all a healthy and happy holiday and New Year. And please stay in touch with the JPL Eye website so that we can continue to give you the best and most up-to-date information. And I want to particularly thank all of the panelists again for participating and for all the wonderful work that the staff from the Council of State Governments did to help us prepare for today's event. If you have any questions, again, please go to the question and answer box.
Thank you so much, Judge Leifman, and to all the panelists and to the attendees. And so we do have some questions that I'll open it up to all the panelists for feedback. So there's a question about the differences between rural and urban jurisdictions and how that might impact trying to collaborate with treatment providers in the community. Just some ideas, particularly I think in rural areas, to try to find treatment providers to connect with that could work.
Yeah, it's really Fred Osher here. It's an excellent question. Challenging issue. There are 50% of the counties in our country that have no psychiatrists, no psychologists, no social workers. And that for those of you in rural environments, access to care can sometimes mean hundreds of miles of transportation. I think that what we have seen is regional efforts that bring several counties together that find synergy and leverage one another's resources. We've seen a great expansion of telemedicine and telepsychiatry that has allowed for improved access in even the more remote areas to qualified health professionals that can assist with screening assessment and follow-up if necessary. So I think there are some mechanisms that rural communities have used to improve access to care, but I know that we have a health professional shortage nationwide, and it's a critical issue for rural communities. Thank you for the question.
And Dr. Osher, this is Allison Upton again, but correct me if I'm mistaken, but I believe I also remember, in addition to the great information you provided, that during the convening that we had, that Judge Stephen Goss from Albany, Georgia, who practices in a rural area, also suggested that the public health providers are often very knowledgeable about these particular defendants, and you know, one advantage that a smaller area might have is that lots of people know the defendants and where they might go and get treatment, et cetera, so that trying to connect, if it's available, to like a public or city hospital or the county hospital might be one avenue to try to find practitioners who know this population and are willing to work together with the court. Is that fair to say, or?
Absolutely, and it is typically, you know, in these workforce shortage areas, the primary care providers that step into this gap and actually have a lot to offer in terms of the management of behavioral disorders.
Great.
I would also suggest that they may want to work with their local county commissioner to see if they can facilitate a meeting between the public hospital or some other primary health provider to see if they can bring telepsychiatry in to that particular provider, and so that they can provide for both their primary needs and their psychiatric needs in the same location.
Excellent. Thank you so much. And we have a question from another attendee who asks, what do the 13 psychiatrists in the Miami jail actually do? Do they provide counseling, or do they just prescribe medications?
It's a great question, because in the past we had 1 or 2 for about 7,200 inmates. Now we have 13 for about 4,900 inmates, and they provide everything. They do counseling, medication management, they do screenings. It's a full array of services. But they also help us expedite the diversion program. So they'll do an assessment to see if the person meets criteria for involuntary hospitalization at time of arrest, and if they do, we have a process in place that works to get the individual out on a misdemeanor within 2 or 3 days into treatment, and then a whole process begins. And similarly, on a nonviolent felony, we have a program to deal with them as well. And they are also part of our public hospital system, and so when the person may leave the jail and go to the same facility on the outside for treatment, we're more easily able to track them and share medical records to make sure that we're doing a better job coordinating their care. Now, I will add this. Before we had 1 or 2, the jail was sued by the Justice Department because of all the poor conditions. And as part of the settlement is how we ended up with 13 psychiatrists.
So again, that collaboration, cross-systems collaboration is key. And the same attendee is actually also asking, and how do you measure the success of individuals who receive mental health services?
Well, for us, it's generally we keep data on all the individuals, and we look at recidivism rates, and we look at arrest rates. We keep data on every single mental health call that our 2 largest police departments make through our CIT program. And so, for instance, we know between 2010 through 2016, those 2 agencies alone handled 71,628 mental health calls, and they only made 138 arrests out of those 71,000 plus calls. So to us, that is great success. We also saw a huge reduction in police shootings of people with mental illnesses, and it's also contributed to the reduction of our jail audit. But once people do come into the program, we track them and we follow their recidivism rate. We know, for instance, on our felony program, that for those that successfully complete the felony diversion program, which is about 65% of the individuals, that program has saved the jail about 72–77% of jail bed days. And so we're looking at 68 years of jail bed days saved because of this program, and relatively low recidivism rate for this population.
Wonderful. Thank you so much for that information, and we're actually just right at our ending point. The time went so quickly. So please, you can see on the screen our contact information. Please reach out to us if you have additional questions or would like additional resources that were presented here from the JPL Eye today. And I just have to thank so much again all of our presentation panel, the presenters from the American Psychiatric Association Foundation, and also from the JPL Eye leadership team. Just want to thank you all so much for your participation, and also to all the attendees today. Thank you so much, and wishing you a wonderful afternoon. Thank you.
Thank you.
Thank you.